So with everything the Supreme Court's been doing, a lot of people have been talking about precedent and how the Supreme Court is disregarding precedent. Well, I got a request from one of my viewers saying, what's the deal with this precedent stuff? Well, let's talk about it in today's video. Hi, I'm Mike Greiner. I'm a lifelong Democratic activist who's concerned about the direction our country is taking. I'm also a lawyer and an academic, and I'm here to help you stand up to the BS of the MAGA crowd. So Susan Collins is all upset about the behavior of Justice Brett Kavanaugh. I mean, after all, he assured her personally and testified under oath that he believed that Roe v. Wade was settled law and so wouldn't vote to overturn it. And lo and behold, what's he do once he's on the Supreme Court? Well, he votes to overturn it. Now, this behavior of his has led to a lot of outrage among a lot of people, in addition to Susan Collins, because, of course, not just did he lie under oath, which raises questions as to whether he should be on the Supreme Court at all anymore, but it points to the fact that this Supreme Court is basically not respecting precedent anymore, that they're pursuing a radical right-wing agenda and are basically willing to disregard earlier decisions of the court willy-nilly. I mean, in addition to overturning Roe v. Wade, they also deemed unconstitutional a 108-year-old law in New York, as well as well-established labor law and voting rights laws. So I guess there are 4 questions that I'm going to try to answer in this video here then. The first one is, what is precedent? Second one is, where did it come from? Third one is, why does it matter? And the fourth one is there some problem with the Supreme Court not following its precedents? So let's talk about each of these questions in turn. The first one is, what is precedent? Well, in typical lawyer fashion, we have a name for it. A name from Latin, of course. It's called stare decisis, which means to stand on the decisions. And that's kind of the principle of precedent, which means that the future decisions are built on past decisions, that they're standing on. Now, this idea didn't just come out of nowhere. It evolved, really, as part of the English legal tradition, of which the United States actually is part of. And really what it dates back to, I think, is probably the year 1066, which is one of the most significant years in Anglo-American history, that being the year that William the Conqueror, who's frequently called a Norman, but really was a Frenchman, it's important to note, invaded England and took it over at the Battle of Hastings. Well, I'm not going to spend a lot of time talking about that history in particular, because I'm sure there are other videos out there on it. But that moment in history is so significant because basically what you had is from that moment forward, you had the development of a new legal system, a new language, and an entirely new culture, all of which were based upon some meshing of what currently existed in England with the French language and traditions and cultures. This is why, for example, English has so many words for the same thing, because a lot of the time, one of the words is from the old Anglo-Saxon English, one of the words is from French. So examples would be, for example, begin, which is from Anglo-Saxon, versus commence, which is from French. And in fact, a lot of the words that we have for things like police, government, judge, justice, prison, all of those things are French words originally. And it's in fact really telling that for the place where we lock up criminals, we have 2 words, one of which is jail from Anglo-Saxon, one of which is prison, which is from French. And the reason for this is literally for 200 years or so after 1066, the language of government, and in fact the word government is a French word, the language of government was French. And just one more little interesting tidbit that comes from this is that that's why we have different names for the animal that says moo. After all, the people who cared for that animal were lower class and spoke English, or Anglo-Saxon at the time, Old English, I guess. And they called that animal a cow. The people who were able to eat the meat from that animal were of a higher class, and so spoke French. And so the meat that we get from that animal comes from the French word for cow, which is beef or bœuf. And you can see that with other farm animals for which we have differing names for the animal itself versus the meat that we eat. And just so you know, that type of distinction doesn't exist in any other language. It's just because of the fact that we had the Norman conquest in 1066. So part of what William tried to do once he took over England was he tried to consolidate power. Part of what he did to do that is he built castles all over England, which then became essentially the tool that was used by the Normans, the French, who were the invaders, to control the countryside that they were in charge of. Another example of that is that William basically took away all the property that had belonged to all the old English nobility and gave it to his supporters, the people who came over and helped him with the invasion. And so to accomplish that task, he engaged in a process of literally assessing all the land in England that there was. And that was compiled in a book called the Domesday Book. And the process that William used to distribute this land to his nobility basically became the basis for the property law that we still follow today in the United States. And as anyone who knows anything about real estate knows, we have some weird names for the kinds of ownership interests that you can have in real estate. And the reason for this is a lot of these terms date back to William the Conqueror. Now, William, as he was trying to consolidate power, he would have different disputes brought before him by his nobility and really anyone throughout England. And he, of course, being the benevolent king, would then resolve them. Well, after a while, he got so overwhelmed resolving all these different disputes that he appointed people to make the decisions on his behalf. These people, of course, were called judges. And the authority that they had to make these decisions came from the fact that they were representing the king. That essentially, they weren't making the decision, they were making the decision for the king. Now, these judges were sent out into the countryside to travel around England to make these decisions and go into different villages and towns and resolve different disputes that had come up before they moved on to another one. And in this way, the king was able to essentially push his authority out into the hinterlands. These judges, as they went around the country, they of course went on circuits, where again we come up with the term the circuit courts here in the United States. So all of this dates way back to England. And by the way, I'm oversimplifying here, but you get the picture. So what happened as these judges were out there making these decisions, they realized that there'd be certain kinds of cases that would come before them again and again and again. And so rather than making the decision themselves, what they'd do is that they'd refer either to an earlier decision that they had made, or perhaps the decision of one of the other judges. And what would start to happen is that the different judges would start to compile their different decisions so that they'd be able to look up, well, how did I decide before? How did this other judge decide before? So that they weren't making decisions that might conflict with earlier decisions that either they had made or that other judges had made. And over time, you had built up this body then of decisions, this body of laws that came eventually to be known as the common law. And what would happen is different people across England would start to rely upon these decisions. So they'd say, well, can I do something? Well, the way to figure that out is to look at the decisions that have been made by the judges in these other cases. And by doing that, you'll know if you behave in a way that is consistent with the decisions that were made by the other judges, you'll know that the judges will again make that same decision because they're relying on the prior laws, the prior decisions. Well, that came to a head in about 1215, where there was a very weak king known as King John, famous from the Robin Hood stories. And I'm not going to get into the reasons why he was a weak king or not, but fundamentally what it came down to is he wanted to do certain things, in particular, tax his country. And he believed, as the king, he had the power to do that. And when he tried to do these things, including taxing his country, but other things as well, the nobility said, wait a minute, you can't do these things. There's this body of law that has been built up over time that says what you can do and can't do. And so you, like everyone else, have an obligation to follow these laws. Well, that was a radical idea at the time because, of course, the king believed his authority came from God. And he could do whatever he wanted because, of course, God had given him the right to do that, right? That led to a big confrontation. And because of the fact that this king was so weak, he basically backed down and gave the nobles what they wanted in return for being allowed to impose certain taxes and do some of the other things he wanted. And that agreement is what we now know as the Magna Carta, or Great Charter. And again, I'm oversimplifying here. But this struggle then between the king wanting to do whatever he wanted and the nobility, really, because until much later, everybody else didn't matter in England, was a central struggle in England that continued through the 17th century, really until the modern era, where now it's just accepted that the laws have supremacy over the Queen in this case now. So one of the ironies with the American Revolution, because of course we were colonized by England and we literally had a system that was brought over here from England, is that while there were certain things we didn't like about what the English did, for the most part, we were pretty happy with the English system. And so we pretty well fully adopted much of the English system into our system. So American property law is very much based upon English property law, as is criminal law, and really all the other kinds of law, which really find their roots in the English system. And one of the big surprises that just about any lawyer has, especially one like me who's a bit of a history buff, is that you'll find yourself reading cases from England to help you understand the law that we follow today in the United States. So that's where it came from. Now, why does it matter? Now, I've already given you a couple hints to that. One in that when students go to law school, basically what we do is we read one case after another, after another, after another. And in general, that's how you come to understand the process of being a lawyer, is by reading these different decisions by different courts over the years. So we understand, as we're taught, that law is an evolution of slow changes to the laws over time, made by courts trying to apply the prior philosophy to changing circumstances, basically. And the other hint that I gave is when I talked earlier about why the English ultimately kind of rebelled against the ability of the king to do whatever he wanted, which is that they'd come to rely upon these laws. They knew how they could behave and how they couldn't behave based upon following the prior decisions of these courts. And that's really what matters here, which is that there has to be some kind of predictability. We don't want to be surprised by rulings of courts. We want to kind of have some expectation that if we behave in a certain way, that way is going to be legal. Or if we behave in another way, it's going to be illegal. Now, I know what some of you are going to say. You're going to say, oh, there's no such thing as ex post facto laws here in the United States. But the reality is that much of the determinations as to whether something's legal or not are done on the margins and kind of the gray areas. So by looking at these decisions and understanding the way the law works, lawyers are able to make predictions that, oh, if our client behaves in a certain way, they'll be able to avoid being sued and ultimately losing a lawsuit. So, for example, on a very fundamental level, if somebody has a contract, say Elon Musk, for example, a contract to buy Twitter, as his attorney, I would say, well, contract law is pretty well settled. You pretty much have to go through with this deal, and Twitter has a right to enforce it, because that's the law. Now, just imagine if after I gave that advice, suddenly when this issue came before the court suddenly decided in a way that was completely inconsistent with the advice that I gave. Well, suddenly people wouldn't know how to behave anymore. And we're finding that situation now, for example, with abortion, where technically here in Michigan, abortion is legal or it might not be legal, because actually there's a law in the books making it illegal in Michigan. But yet the Attorney General and the governor have said that they're not going to enforce that law, and they were actually challenging that law in the courts. But after the recent Supreme Court decision on abortion, nobody really knows what the rule is on abortion, and nobody knows when it will change or if it will change. So we're finding that a lot of the large providers of abortion here in Michigan are deciding they're just going to get out of it because they don't know what the law is. And that's the risk when you don't have courts following precedent, is that you lose that predictability. Now, that explanation gives you a little bit of an idea as to why society as a whole suffers when courts don't follow precedent, and why when the Supreme Court suddenly does a complete about-face as to its prior decision, suddenly it causes a problem for society as a whole. I mean, just imagine what would happen if suddenly the Supreme Court decided that gay marriage was not something that was protected here in the United States anymore. There would be all this chaos as to whether these people who'd been married during the time period that gay marriage was legal were still married, right? And that's the kind of situation that we find ourselves in right now. You see, if people didn't follow the law willingly, for the most part, there's no way that society would be able to operate. I mean, we do have police forces that can use the power of the state to enforce the laws, right? And throw people in jail when they don't comply. But just imagine if anything more than a tiny, tiny percentage of people didn't comply. Suddenly the police forces would be overwhelmed and society would rapidly descend into chaos. So we rely upon people's willingness to follow the law to keep society operating correctly. Now, to do that, there needs to be some basis for people to believe that the law is based on something other than just the whims of some person who happens to be in power at the time. So back in the old days of kings and queens, the reason people followed the law is because they believed that it was coming down from God. It seems quaint for us to think about nowadays, but even kings and queens were afraid of the Pope because the Pope could excommunicate them. And if that happened, they would go to hell. So the thought that there was some direct line coming down from God through the Pope, through the kings, through the judges, that then led to the laws that people were supposed to follow, gave them some sense that these laws were based on something serious. They weren't just arbitrary decisions made by people who just happened to be in power at the time. After all, they were coming from God, right? That concept, by the way, is called legitimacy, that there's some legitimate basis for the laws. And as a result of that legitimacy, we're able to accept these laws, and most of us will follow the laws. And for that matter, people will respect the decisions of courts, including the Supreme Court, by the way. I mean, there's a famous quote by former President Andrew Jackson that upon hearing of one of the decisions made by the Supreme Court, that he said, quote, "John Marshall has made his decision, now let him enforce it." In other words, the President of the United States was saying that, I don't care what the Supreme Court says. I'm going to do what I want to do. And the truth of the matter is, there wasn't a whole lot the Supreme Court could do about it. So the only real power that the Supreme Court has, or any court for that matter, is this sense of legitimacy, that somehow we should respect what the court's deciding because their decisions are based on something more than just personal whim. Now, in the United States, obviously, we don't believe that the authority of judges and the government comes from God. No, in fact, in the Constitution, we're quite explicit as to where we think the authority of government comes from. It comes from the people. Remember the first words of the Constitution, "We the people of the United States of America." And what the Constitution is essentially a contract between the people agreeing that we will agree to be bound by this system so that we have a society that can operate successfully. And there will be certain people who don't want to comply with the decisions that are made in the system, but the authority to enforce these laws then will be based upon essentially the agreement of the vast majority of people of the country. Now, courts, obviously, at least in the federal system and in many states, are not elected. So they don't have that authority coming from the fact that they were elected by the people and can be essentially taken out of office by the people who put them there. So they have to draw their legitimacy from something else. And the place that they have drawn their legitimacy is from this idea of precedent. In effect, they argue that they're not making up the laws. They're basically taking what has been an established law over time and simply applying it to a new set of facts. And that's why precedent matters so much to the Supreme Court, and why, frankly, Chief Justice John Roberts is very upset about this decision on abortion and fought very hard against it, even though he likely agrees with its end result. And the reason is that he's concerned that it undermines the legitimacy of the court. That if people believe that the court is simply making decisions based upon their political ideology and nothing else, well, all of a sudden, they seem like they're just these people making arbitrary decisions that really there's no basis for us to pay attention to, right? And that is a real risk that the Supreme Court faces in its current trajectory. Well, this has already been a way too long video, but I hope maybe you got something out of it. If you're interested in seeing a video where I talk about how the justices themselves have been concerned about this eroding perception of the court's legitimacy, why don't you check out this video over here. I'll see you then. In the meantime, let's hope for continued progress. Thank you.